Good morning. I'm Nate Bernstein. I'm the managing counsel of the LA Real Estate Law Group. We are the premier Los Angeles real estate firm in Southern California. We specialize in real estate litigation and transactions, business law and business litigation, and also bankruptcy matters, including creditors' rights matters in state court and federal bankruptcy court. Thank you for tuning in. I really appreciate you taking the time. Today, in a two-part webinar series, I'm going to discuss sage advice for effective negotiation in real estate transactions and legal disputes. These are some basic tips you can use in any real estate transaction matter where there's a dispute, or a legal matter where there's a dispute and you're looking to resolve it quickly and efficiently. So here we go with our negotiation and strategy tips. Number one, most transactional and legal problems, situations are negotiable. Don't ever let someone tell you that something is not negotiable. Most things are. So unlike the sale of a Tesla or a Saturn car, you can negotiate a resolution by giving and taking. So first of all, try to negotiate a settlement and believe that most situations are negotiable. Number two, in negotiation, the image of rote power is not the most important factor. The most important factor is really trying to achieve common ground with your opponent or adversary. The challenge is for David and Goliath to come to common ground on material points, and for both sides to avoid worst case scenarios. So if you have some financial or legal leverage, don't abuse it. Try to come to common ground with your opponent or adversary. Number three, at the end of every negotiation session, you're trying to achieve a consensus or agreement. So keep this in mind. The parties receive something of value, and they also give up something of value. In every successful negotiation session, there's giving and a taking. So try to give some benefit, and of course, try to get some benefit. And try to assume a burden, a small burden, and also try to alleviate yourself of a burden. There's always giving and taking in every session, every successful negotiation session. Number four is the issue of good faith. Assess whether your opponent or your adversary is negotiating in good faith or just posturing and bluffing. Sometimes an opponent may be using a negotiation session for the purpose of obtaining knowledge and not really to achieve a settlement. This happens in legal mediation or in settlement conferences. So really assess whether your opponent or adversary is acting in good faith or is just bluffing and wasting your time. If they're wasting your time, then it may be not the right day to negotiate a resolution. Number five, if you don't believe or trust what your opponent is claiming in a session, ask for documentation or some legal authority to back it up. Do your investigation and due diligence so that you have material information or material legal authorities that are relevant to the situation to make an informed decision. Put your opponent on the spot a little bit. Ask for backup and some proof when you're about to settle a claim. Number six, be detail-oriented in your quest for making a deal or an agreement. Think of all the details that you want to achieve and list them in a simple way. The parties want transparency, and for you to know the details, you need to ask the right questions, deal with the details, and make a list so that all issues are addressed. If you don't understand an issue, ask an attorney, ask an expert, ask your opponent for clarification. Very important to be clear, and to understand the details in any negotiation. Number 7, don the hat of your adversary or opponent to understand the details of what the adversary wants. But don't believe everything you hear. In other words, think out of the box a little bit. Assume that you are your opponent. What do they want and what are they seeking in a negotiation? And is the other side being reasonable? If the other side is offering a particular offer or suggestion, don't believe everything you hear and take anything your opponent says with a grain of salt so that you can make an informed decision. Number 8, we're going to go through 10 points, so this is number 8. Listen to the other side carefully and try to achieve some common ground on major points. Many negotiation sessions fall apart because one side has to win on every minor point or an insignificant point. This frequently leads to an unsuccessful negotiation session. A lot of times your opponent just wants to vent and to advocate their position. So let them talk for a while and hear what they have to say, and then try to achieve common ground. Number 9, very important, understand the concept of worst-case scenarios and what it will cost to avoid them. This is very important. There are generally 3 types of worst-case scenarios in any negotiation session: financial, social, or legal. Sometimes you have all 3 in a particular issue or case. This is especially the case with real estate contracts that shift attorney's fees and costs to the losing party. If you go to trial and you lose the case, you risk being liable for the other side's attorney's fees and litigation costs. So understand the worst case scenario. Understand the legal, social, and financial ramifications if you come up as a loser at trial, or if you come up as a winner at trial and you get attorney's fees, can you collect them from the other side, or will they file bankruptcy? That's a very important factor. And number 10, fortify yourself with a briefcase full of experts and reports and data to show that you are strong in your position when you go into a negotiation session. Experts may include appraisers, surveyors, engineers, licensed contractors, plumbers, real estate brokers and agents that have knowledge of the neighborhood and comparables, other trade professionals, and God forbid, attorneys. If your attorney is well prepared and is an expert in his or her field, that really helps you coming in to a negotiation session. So these are 10 tips, very important tips that you can use generally in any legal or real estate negotiation, whether it's a complex legal matter or it's a real estate negotiation session on a particular area of dispute between a buyer and a seller. And this is part 1. I'm going to also do a part 2, which I'm going to give you 10 more tips on how to negotiate legal and real estate disputes and problematic situations that will help you resolve your particular problem so that you can move on and get on with your life. So I thank you very much for listening to this presentation. My name is Nate Bernstein, and my law firm is LA Real Estate Law Group. Our website is www.larealestatelaw.com. That's one more time, I'm sorry. www.larealestatelaw.com. And our phone number is 818-383-5759. If you want to consult on any particular issue, whether it is a legal dispute, a real estate matter, or you're trying to negotiate a resolution of a problem. So I thank you so much for your time. I wish you all the best in your negotiation, and I hope that all of your sessions are very successful. Thank you, and have a great day.